In a case of bizarreness, we're going to look at Bruce Lehrmann's latest move. So we've got to go. He filed. So we knew that he had until the 31st of May to file his appeal to the federal court against his loss of defamation, which he did. If we look at this document here, this is the Federal Court, New South Wales Registry, Bruce Lehrmann, Channel 10, and the law. It was filed on the 31st of May. It has not been made a public interest document yet, so we have no idea. But it's got notice of appeal and the address for service. So we haven't had actually any official document signed, other than the fact he's put in his notice that he intends to appeal. And of course, there's no orders yet. So there's nothing yet. So he's decided to appeal. He submitted his documentation. On the 4th of June, this was filed. It says mystery continues to surround the details of Lehrmann's appeal. Bruce Lehrmann, and there's a spelling mistake, has continually denied claims he argued Brittany Higgins inside Canberra's Parliament House. However, in the recent defamation judgment, Justice Michael Lee found that on the balance of probabilities and the civil standard of proof that something he did assault her, but does not amount to criminal guilt. On Friday, Federal Court confirmed Mr. Lehrmann had lodged the notice of appeal before hours. Now, it will be heard by 3 full bench judges. That's how the appeals work. You have 3 judges instead of 1. This was an interview done by the Australasian lawyer on Thomas Gear, partner of the biggest impact of the Bruce Lehrmann defamation ruling. The decision could set a precedence for future SADV cases. So the long-running saga, so this is with the lawyers that worked for Channel 10. So partner Marlia Saunders led the Thompson Gears team in successfully bringing out a favourable outcome for Network 10. Saunders described the court's decision as long overdue vindication for Brittany Higgins. So there's the first part. So can you tell us about the work that they did on the 10 case? So the teams worked closely with barristers Dr. Matt Collins and Tim Senior. They prepared and ran the case and proceedings. So in Australia, the solicitors or general lawyers, they do all the grunt work and prepare everything. They're the person that the clients deal with, and then they have these barristers, and barristers are not assigned to any law firm. They're impartial. They can be working on several different cases. They're the ones that have to face the judges in these big cases. So they had to go through the ACT Department of Prosecution, review all the records, CCTV to text messages. There were downloads of mobile phones. There was tens of thousands of pages that they had to go through. They conducted independent investigations, went through all the transcripts of evidence from the criminal trial, spoke to witnesses, prepared affidavits, outlines from more than 20 witnesses, prepared an expert report from a forensic psychologist, a toxicologist, and a lip reader. And they had to try and piece together what happened that night as the most probable, which the judge found was the most likely version. So she says it's hugely significant. It's the first time the court has made a finding about what happened at Parliament House on a night over 5 years ago because the criminal trial was aborted due to jury misconduct. It does provide a long overdue vindication for Brittany Higgins, and it should provide some level of comfort and hope to other SA survivors. The reason for this is this. I'm hopeful that the way Justice Lee approached his fact-finding task in his judgment by recognising the impact of trauma on memory and the difference between a false memory and a lie will be implied in future cases involving allegations of SA and other types of cases like DV cases. Justice Lee recognised the inconsistencies in versions of events are byproduct of the frailties of human memory and the effect of trauma, and shouldn't be used to undermine a core allegation like SA. I think that the use of the myths against complainants in an attempt to discredit them needs to stop, and I think that this judgment is an excellent step in the right direction. The issue of SA is incredibly topical at the moment, so the timing of it all. At the moment, they've got a new senior counsel who's looking at the evidence, so this was about his appeal, and the judgment's 324 pages long, giving some expert opinions. So it talks about what does it mean for the network 10. It says, well, I think it shows that it was a really important story that needed to be told. The fact that it's been found that an R did occur in the nation's capital, in the very building where our government operates from, is a hugely important story. It was very much public interest. And I think that the fact that Justice Lee put on open justice, the way he ran the case was to provide access to all the public, all the hearings, documents, evidence. It meant the public really had the first-hand view of the legal process and direct access to evidence to be able to view it all and see the wheels of justice turning. And I have to say that is very important because he did keep it open. And I think that's a really important aspect of the case. We just saw it. So here now, he is appealing, and he's saying he first of all is going to be self-represented, which I feel is crazy myself. All right, but he's on procedural fairness. The court documents reveal former Liberal staffer plans to challenge findings made against him in fairness. He has lodged the appeal. The findings meant his bid to sue Tennant failed because they failed to bring the truth defence. The notice of appeal states the documents were prepared by Mr. Lehrmann himself. Yes, he's filed it himself. Mr. Lehrmann launched a defamation action after his criminal trial was aborted. So the notice of appeal to his filed defamation action claims the finding that the truth defence was contrary to the evidence and did not reach the standard of proof required by a trial judge. The notice took aim at Network 10 and Ms. Higgins. A full review of the evidence and the findings by the trial judge, together with significant credibility problems of the first respondent's primary witness, would satisfy the Court of Appeal that relevant provisions of the Evidence Act have been misdirected, the notice said. It was not open to the judge to find the case he did. The notice also pointed out the notice also pointed to differences in the accounts of the incident suggested by the project interview and the description in the recent judgment. The broadcast suggests a violent R, where the complainant was in tears and repeatedly refused consent, of which repeated refusal of the perpetrator must have been aware of said. This is contrary to the non-violent R involving inadvertent recklessness as to consent, which was ultimately found in the judgment made by the trial judge. The notice also complains about the way costs were allocated and asks if the appeal is allowed that any judge other than Justice Lee be appointed to assess the amounts. So he didn't like it. Yes, he's talking about violent versus non-violent, and as far as I'm concerned, there's no difference, correct? I'd be interested to see what you think. I think he's clutching. Says this one says law student Bruce Lehrmann has shocked the legal fraternity by announcing he will go it alone to represent himself in his high stakes appeal. He's always denied that he had sex with Miss Higgins and maintains his innocence. He's in his second year of law studies at the University of Notre Dame, lodged paperwork in the federal court for a fee of $1,635, confirming he's self-represented. Well, I'm a second-year law student too, and I don't think that I'd be able to represent myself. His appeal application states the grounds are the case found outside the pleadings, that there was a denial of procedural fairness. It states that on the case of justification, as found, was not pleaded by the second or first respondents, was not in evidence of primary witness of the first respondent. The trial judge breached procedural fairness in allowing a case to be found that was not pleaded or addressed by the person's second respondent or in the evidence of the primary witnesses. He also references the bruise photograph and notes that the judge had concerns about this evidence. The broadcast, and then he talks about the violent and non-violent. He has not engaged an barrister at this stage to appeal. Contrary to media reports from our barrister, Margaret Cunning confirmed she was not involved in the appeal, nor is Guy Reynolds, who was initially consulted. Instead, he lodged the paperwork and signed it himself. It will be considered later this year by three federal court judges in the Court of Appeal. It follows Justice Michael Lee's finding on the civil balance of probability that he did, Miss Higgins in the minister. The documents had not yet been served on Channel 10 and Mr. Wilkinson. So I'm interested. I want to hear from you. What do you think? Look, he has every right to appeal. I don't know how much success you'll have, because I think the fact that it was open in an open court and everybody's been able to see everything, we can go and look it up and you can see all the evidence there. You can see that everything's there. And I just, in my opinion, it just looks like his arrogance, in my opinion. He came across as being very arrogant. It's just my opinion. He still maintains he did nothing wrong. He still has a case in Toowoomba that he has to deal with. There's still the Toowoomba matter to deal with. So he has still got some other things. I mean, I don't know whether the civil stuff's going to be able to be used in the criminal stuff in Queensland. I don't know about any of that. But it's a very interesting situation. But as I said, apparently I don't even know how I would feel having him in my law class. I don't know how I'd feel having to sit classes with him because of the allegation. I mean, and again, he's been found at a civil standard, not a criminal standard. So just because he's been found at the lower standard doesn't mean that they had the higher standard. At this stage, they didn't have a higher standard. And the other thing that's really shocking and surprising to me is that there's been nothing that's come out of Parliament about this. There's been nothing to say. We're absolutely horrified that, we want to make changes so that this never happens again. And I haven't seen that Parliament at all. So that's very concerning from my part. Anyway, that's all I've got for you. So thank you. I'm using Streamlabs at the moment. I'm now having to get used to another one. So thank you for watching. Please make sure you hit like and subscribe, and I'll keep you informed. I've got another couple of videos to record, and I'll catch you again soon. Bye for now.